Hi everybody. Today is just going to be a short video to answer one very important question, one very common question that I get a lot when we're administering probate estates. And that question is, if there is real estate that is owned in the estate, is the executor required to just hold on to that real estate the entire time the probate estate is ongoing? Do you have to continue to pay the insurance and the taxes and all of the other carrying costs that are associated with owning real estate during that whole probate process? Which, if you've watched any of our other videos on our YouTube channel here about probate, you'll know that probate is a really lengthy process that can take a year or more. So those costs can add up over time. So it may be very desirable to sell the house again, just so the estate and the beneficiaries maybe aren't incurring those expenses when the plan is really to sell the property. So the simple answer to the question is yes. Even though probate is not finalized, the executor or the fiduciary appointed for the estate can sell the house. So they're not going to be required to hang on to it for that whole year period and just let it sit there. So that would allow the fiduciary to sign the listing agreement. The fiduciary can sign the purchase and sale contract once a buyer is found. And it's also going to allow the fiduciary to sign the deed to the new buyer and any and all other documents associated with the closing. So the fiduciary for the estate is going to have the authority to do that. So that's the good news. One catch, though, is, if you want to call it that, is that anytime there's real estate owned by someone at the time they pass, the state of Connecticut does put a lien on the property for potential estate taxes and probate fees that might be due. So you're going to want to get a release of those liens before you close, because really any buyer isn't going to want to purchase a property with liens on it. They're going to want to see that those liens have been released so that they own the house free and clear. So in order to get those releases, what you're going to need to do is file the estate tax return with the probate court. And if it's towards the tail end of the probate court process, this is something that might have already occurred, because filing the estate tax return is a standard step that we do in every estate. So if by the time you've gone under contract and you found a buyer for the house, it's again towards the tail end of the probate process, you may have already gotten that release and have it recorded on the land records, in which case you're all set. If you haven't gotten to that point in the probate court process, so maybe you're still closer to the beginning of the process or just started probate, you're going to want to make sure you get that estate tax return filed as soon as you can, just because, again, you're going to want to get that release, or you're going to need to get that release of liens before you're going to be able to close. So the way you do that again is you want to make sure the estate tax return is filed. It's going to report all of the assets owned by the decedent, both probate and non-probate assets. But so long as the total amount of assets reported on the estate tax return are less than the estate tax exemption, there's going to be no tax due. So just because you're filing the estate tax return doesn't mean there's going to be a tax. More often than not, you're just simply proving to the estate that there is no tax due. And again, that's more common, I say, just because currently, as of 2022, in order to owe an estate tax, the decedent had to have owned at least $9.1 million. So assuming the decedent's estate is under that threshold, there's not going to be any tax due. You're going to file that estate tax return, get that release of lien. The release of liens then also needs to be recorded on the land records. So again, if you're towards the tail end of the probate court process and you've gotten that release of lien, you've probably already sent it into the town clerk to be recorded, again, in which case you're all set. If this is, again, where you are getting this release a little bit earlier than you would have probably initially, just because you've gone under contract to sell the property, a lot of times what happens is we file that estate tax return, again, once the property has gone under contract. So by the time we get the release and provide it to the buyer, it's a document that's likely just going to be recorded with the other documents at closing. So there may not be enough time to record it ahead of time, but that's okay. So long as you get that release to the buyer's attorney, and it's going to get recorded along with the deed conveying title to the buyer, you should be all set. So that's my short answer to, can you sell real estate while probate is ongoing? So again, kind of in summary, yes, you can, but you really are going to want to make sure you get that release of liens before you close.